Okay, welcome everyone. This is to Hot Topics when medical conditions impact the workplace. And as we've said in past podcast episodes, is that both Felicia and I have been around for a while, and we have seen a proliferation of medical conditions and various types of medical conditions show up in the workplace. And so creating some new challenges, definitely shifting perspectives, and a world of continuing evolvement. And so we're delighted to be here today. And with me, I have Felicia Amento. Welcome, Felicia.
I'm happy to be here.
Great, great. And so one of our goals with this podcast is to, share some of the experience that we've had over our respective, I'm not even going to say how many years, but it's lots, and spans more than a couple of decades, let's say that. But also because we're constantly challenged in keeping abreast of what's happening in the law, what's happening in decision making, court rulings, things like that. We founded this venture, 3-4 years ago now, Felicia?
Yes.
Yeah, as a means of sharing this information with all of the people that we serve throughout San Diego and Imperial County, and of course being on the web. I hope it goes further. But it's an interesting world to be in. And I oftentimes will open up my interactive process meetings by saying, until you have a medical condition of your own, or until you have an employee with a medical condition that you're dealing with, few people know about the labyrinth of laws and processes and this whole world of disability management of medical conditions in the workplace. So we welcome you. Thank you for being here, joining us on this journey. And so we have some interesting topics today. And just as a reminder to everyone is that this is being recorded. And so as a pre-registrant, you will be receiving a link to the recording so that you can listen to it again and or share it with your coworkers. We invite you to pass it on, particularly to your bosses, so that they continue to be enlightened about what's happening in the world of medical issues in the workplace. So we have a few, 4 topics to be specific. There was some subsets. First of all, Pepsi is in the news for violating the ADA. And it's an interesting little story. And so we'll take you on that little journey. And then number 2, the United States Postal Service is back in the news again, this time not for going postal. And so we had an interesting discussion recently about what postal now means, and sort of a disservice to all those many great postal workers, but it is what it is. But how wrongfully discharging somebody in a probationary status. So that's another little, I don't want to say wrinkle, but another little element to be aware of. And then number 3, we're taking a look at some new guidance about EEOC and disclosure of medical information for accommodation purposes. And so it's, and this particularly applies to new hires, as well as candidates. And so it was, I sort of learned something new, or maybe I got it confused over the years, who knows? But it's always good to refresh. And then our last one is we have several different subtopics that we've been working with around fitness for duty. And as I shared with Felicia and getting ready for today's episode, I've seen more requests for fitness for duty in the last few years than I did in the first few years. I'm sort of going pre-COVID and post-COVID. But yes, it's they're alive and well, and there's a purpose, there's a reason, and there are some components of the law. And so we're challenged with some of these issues right now, and so we thought it would be good to bring it up. So we will get going and diving into our topics. And so Felicia, another credible journey. Would you agree?
Yes. Yeah. Been busy right now, right? With the end of the school year coming. There's a lot of stuff happening.
Oh, absolutely. Absolutely. And so, with that, I know we've talked about in past episodes, you might want to check back into one of them, but we did create a checklist about, wrapping up the school year, getting ready for the next school year when it comes to your employees with medical conditions. I'll just add that far too often coming in to facilitate an IPM, we have seen people that have gone unchecked, and in terms of their temporary accommodation. and they've been allowed to go far longer because nobody's watching the wheelhouse.
Right.
And so that's something to, I know it's a busy time, but sort of take a look at the people you have on temporary modified, temporary alternative, or even those who've been out of work for quite a
Right.
long time. Those are good cases to check in on where are we now as we get ready for the new school year. So just a reminder, and if you need the checklist sent out to you, please email me, at dr.dupree@relationships-at-work.com. I'll be happy to share that with you, but it is in the past episode. Okay. So Felicia, Pepsi, Coke, whatever it is, Pepsi, this one's Pepsi. Okay. Okay.
I'm going to refer to them as Pepsi. They call themselves PepsiCo, but I think we'll all know who I'm talking about. It's a big company. And I thought it was an interesting case. I use cases to show that are non-industrial and industrial because the disability doesn't matter. It's really understanding what ADA and what the EEOC is looking at gives us really good guides of things to do and things not to do. So I made lots of notes because it's kind of a complicated story.
It is.
EEOC claimed that Pepsi violated the ADA when it denied a blind employee's request for accommodation, in part because it was too expensive. Pepsi violated the ADA, and then they later fired a call center worker who is blind. The EEOC alleged in a lawsuit that was just filed about a week ago. This is in the U.S. District Court in North Carolina. The employee notified Pepsi of his disability prior to his start date, and he requested an accommodation that would allow him to perform the essential job functions. He referred Pepsi to a vocational counselor that he was working with, who offered to assist Pepsi by conducting a technical assessment and helping them purchase some needed equipment for the employee. EEOC alleges that Pepsi rejected the counselor's offer of help and instead on their own tested 2 screen reading softwares, but they said they were incompatible with their own system. And Pepsi said that rebuilding their systems would take 1 year and cost $1 million. That's what they stated. Pepsi was already planning to replace its customer-facing tracking system by 2025. And that what they said was that this software for the accommodation wouldn't be compatible. And Pepsi allegedly told the employee that it looked for other jobs for him, but, quote, they could not find anything that did not require the use of their system, or it was not suitable for him. And then they fired him. And the EEOC claimed that use of a screen reader was a reasonable request, and it would have allowed the employee to perform the essential job functions. And EEOC said that applicants and new hires are particularly vulnerable to disability discrimination. This is where what not to do comes in, right? Be careful with these people. The employee often, this is the EEOC's advice, the employee often does not yet have enough information about the employer's operation to recognize and assess potential reasonable accommodation. It is incumbent upon the employer to share information and to work with an employee or their advocate, in this case, the vocational counselor, to identify possible accommodations. So them refusing to, to listen to any of the counselor's advice was not a good thing, right? EEOC asked the court for injunctive relief as well as back pay with interest, punitive damages, compensation for the employee's past and future losses of employment. So EEOC's advice was the employer may encounter a number of pitfalls when handling accommodation requests, and such as inadequate training or general resistance to the process. And that is something that we talk about. That's that inherent bias. This is too difficult. We don't want to work with you. The answer is just no, go away. You really want to avoid that. You want to avoid that generalized resistance to the process. And you do not want to have people in HR or workers' comp that are handling these things that are not trained adequately, that do not understand the ADA and EEOC. So really, when you think about your supervisors and managers, they all need to understand that this is really rocky waters and you need to be careful how you proceed. And Pepsi is a big company, right? To say that new software was going to take a year and $1 million, the EEOC was like, no, we don't
No,
think so.
no.
And you've worked with lots of these disabilities, right? So.
Yes, absolutely. Yeah, and in fact, I've had several cases in this last year that specifically are focusing on hearing impairments or visual impairments, and
Mhm.
including total hearing loss as well as total vision loss. And so it presents some unique challenges, but again, they're smart people, they're educated, they have a right to work, and so it's how do we do the job differently, and where do we need to do the job differently? So, yeah, and so what you're referring to, Felicia, is, another term is implicit bias, where we have these internal biases towards people who are different or who have different needs than maybe the usual employee, and that we immediately cast them off. And so that's exactly what these laws are designed to prevent, in the sense of, the goal is always to keep people working whenever possible so that their medical condition does not interfere with their gainful right to be employed. And I'm remembering a situation of where I used to do a lot of work with a major power and water utility, and I had one, mid-level manager who was not a happy camper when it came to his employees in the interactive process, difficult. And then his own son, who also worked for the same employer, was very significantly injured. And oh boy, did his tune change. And he became one of our most avid supporters. But again, he had such a bias, such an attitude. It was so prevalent, so apparent. And employees pick up on that. And so if they're seeing
Yes.
that an employer is not working with them, doesn't bode well for the employer.
Okay.
Yep. So yeah, so huge, again, particularly given the size of the company, it's like, I'm sorry, too expensive? The EOC didn't think so. Yeah. And so that's something to consider, is that, again, we need to have an open mind to what are an employee's needs, and be mindful of any kind of bias we might have going into the process. And I see a shift, it's a different world today than it was 35 years ago when the ADA was implemented. And so attitude management leadership has changed significantly, but it doesn't mean that there aren't still outdated notions of thinking. So, yeah. So on the next one, USPS, discharge a probationary employee. Let's dive into that one.
So this one does have to do with workers' comp. So, meaning it came from a work-related injury, but I thought that the facts were really interesting because a lot of people feel like, oh, they're on probation, right? This is like not something that most people would think of as a pitfall. We still have to be careful about discriminating against people that file work-related injuries. So this was in federal court. They found that the United States Postal Service wrongfully fired a probationary mail carrier after a workplace injury. This injury took place in Portland, Oregon, for the Postal Service there. And this case was already tried, right? So this case, after a 2-day trial, the U.S. Department of Labor obtained a federal court judgment that ordered the Postal Service to pay over $141,000 in lost wages and damages for emotional distress suffered by a probationary mail carrier employee who they fired after she reported an on-the-job injury to her supervisor and filed a work comp accident report. The judge found that the Postal Service discriminated against and wrongfully terminated. This is during probation, right? The employee 21 days after the employee reported a leg injury that she sustained near the end of her shift as she was unloading mail from the mail truck. And they fired this employee 11 days before her probation ended. Very important, right? And the judgment followed an investigation by OSHA. And the judge noted that the Postal Service failure to document their own forms about timely evaluation, any evidence that was evident of their retaliatory intent. That's so meaning that's the discrimination against, there wasn't anything else about the employee that was documented. Federal law forbids employers from taking adverse actions or punishing employees who report an injury or a workplace hazard, even like if they report like a safety item to OSHA. Federal court said we will continue to combat retaliation and ensure that employers protect their workers, even probationary employees, right? So that's still not, that was not a safe harbor for the Postal Service to do this. And this is a separate law. What we're talking about here is really outside the workers' comp system, right? This is a Department of Labor federal case. There's also state law in California that protects discrimination against employees, and that is filing a 132A against an employer. And that is a penalty that is not insurable by workers' comp and has to be paid directly by the employer or the school district, the fine itself. But this is in addition, this is a separate issue from that because this is the Federal Department of Labor. So I thought it was kind of an interesting case because it was a probationary employee and it was an employee that there was no other documentation there was nothing else but this, that they filed an injury. So I thought it was an interesting case from that standpoint.
Very interesting. Yeah. Because as long as the employee is qualified and they've been hired for the job, certainly it's appropriate to have them do a pre-placement physical, or have a probationary period. Yeah. I mean, that's reasonable, but they're still employed. So again, if anything happens to them, work-related or non-work related, then it's important to realize they are still employed and they're still, afforded the rights to, for accommodation under the laws that we talked about. Yeah. I'm curious, Felicia, before we move on, with the 132A, that is particular. Well, I've always heard it in reference to workers' comp, but I imagine it has application to other
it is a work comp law only,
okay.
and yes, and it's not a covered, it's a penalty, just like the penalty against serious and willful misconduct. They're not insurable. Your work comp, TPA, or pool cannot pay for it. We do have a couple right now. They're unusual to see in our school districts because what they're alleging is that they've been specifically singled out and discriminated against because they filed a work comp claim. It's very specific allegation, and that is a California thing. That's not a federal like the Department of Labor. But we do have some filed right now, and we're working through them. There are not very many school districts that do that, either intentionally, because you have to prove like willful intent, right, to discriminate against them. Kind of like this case, right? There was nothing else about the performance other than the fact that she hurt her leg and filed an injury. And that's where they really got dinged, right?
Right.
They couldn't come up with any other reason why they terminated the probationary employee.
Right. And I know I hear this come up in the IPMs where employers may be fearful of, facing a 132A wrongful termination, if somebody has exhausted the benefits and, and there's no accommodation possible. And it's like, well, you got to follow the process. And at least for school districts, you've got that sort of added layer, I think, from the education code, is that, if they ultimately cannot work, then they have to go into the 39-month rehire, so as I oftentimes say, it's, we have several laws come into play. The IPMs are largely driven by the ADA and FEHA, but we have to take into consideration the Ed Code, Workers' Comp, FMLA, and some other laws too. So, yeah.
That's what keeps you and I busy, right?
Oh, yeah. Just had the whole Pregnancy Work Fairness Act come into play recently too. Pregnancy led to other things, and now we're into the whole works. Okay, yeah. And so we getting to some of the subtopics as far as EEOC and when are employees responsible for disclosing that they have a medical condition that may require accommodation. And so I found our own pre-talk very interesting about this. And so I'm looking forward to having this discussion right here now.
Right. And I took a little more notes on this because this is the EEOC's latest guidance because of this case that's come up. So it's when when candidates for new hire have to disclose the need for accommodation. That was kind of the question that came up out of this case. And so what EEOC was reminding employers in this case is that the ADA does not require candidates to disclose disabilities in their interviews. And the warning came as the EEOC sued an employer alleging the company fired a new hire for failing to divulge disability information before they started work. So this case has specific facts. So I tried to really make notes to be clear. So this happened in Maryland, and this lawsuit was filed in May. So this is recent. This is still going on now. This is against a medical care clinic. On her first day of work, a scheduling assistant for the clinic, this is her first day at work. So she's not an applicant. She's already gone through that process and been hired. So on her first day of work for the clinic, she notified the CEO that she had a vision impairment and that she needed a magnifier and a Zoom texting software as an accommodation on the first day. The CEO allegedly advised her that things would have been different if she had mentioned her disability and her accommodation needs during her interview process and told her to leave. First day on the job, leave, fired. EEOC sued the clinic for violating the ADA. And this is their advice. Under the ADA, job applicants do not need to reveal their disabilities before being hired. When an employer penalizes an employee for not raising the issues of a disability, whether it's industrial or non-industrial, and a reasonable accommodation need, it is requiring the employee to reveal information the employee legally does not have to divulge. And then the EEOC, as they do often, is giving guidance, takeaways for hiring practices. Number one, employers should remember that the ADA generally prohibits them from considering an applicant's disability when making hiring decisions. Number one. Number two, the job interview is the second area for slip-ups, for asking illegal questions of the applicant, like interviewing for a position and asking disability-related questions. Some of the questions that they gave as examples are asking about the use of walking with a cane or a wheelchair. What's wrong with you? How bad is your disability? Or declining to hire them because of a disability they can see, right? That's right there. So what they were saying to guard against employers unlawfully considering an applicant's disability in the selection process, the ADA generally prohibits them from asking disability-related questions until after the applicant has been given a conditional job offer. And the EEOC guidance explained, some inquiries are allowed. Employers can ask if they will need an accommodation to perform a specific duty. They gave an example because the EEOC does this. Sometimes they'll give other examples that kind of help you with what they're thinking. This one employer, they have to use power equipment. And they were asking the employee, can you work with power equipment, power tools? And I want to say it was like a construction company, they build things. And the employee had narcolepsy, which is where you can fall asleep, right in the middle. Well, this inquiry and discussion was okay, the EEOC said, because there was very few exceptions where you could make that safe, right? Narcolepsy with power tools is super dangerous, right? Because you can fall asleep suddenly with no warning right in the middle of what you're doing. But for the most part, they're saying you want to stay away from doing that. So I thought it was interesting, and some of the takeaways that it's not that you cannot ask if they'll need an accommodation to perform a specific duty, but you can't ask things like, why are you using, what about, can you talk to me about your use of a cane or your wheelchair? And they gave like literal questions that employers have really asked employees. Looks like you're disabled. How bad is it? And what's wrong with you? What's wrong? I can see something's wrong with you. Can you tell me what it is? These are things you cannot do.
Yeah, yeah. That's so interesting because, even the examples that you gave are, are reflective of some of the, languaging that, people use that are so biased right from the get-go. What's wrong with you? That's an assumption that there's anything
Yes.
wrong, and, and as many people with, disabilities, for example, like wheelchair users, that was a big focus back in the 1990 when the ADA was passed. Um, it's like there's nothing wrong with me. I have a different way of ambulation.
Mm-hmm.
Okay, and that's true, and so not use of the wheelchair did not impact performance of the essential functions in any way. Um, what I was always trained in, as far as candidates and new hires and so forth, is again an appropriate question would be is that here are the essential functions of the job. If you had a chance to review the job description, so make sure you have a job description at the interview. Are there any essential functions that you may or may not need an accommodation for? And in terms of performing or something like that. But so by basing it on the essential functions, is there anything here that you may be challenged in performing, and how might you need an accommodation? And so that's interesting. And the whole thing about not asking candidates ties back to what we talked about earlier, where like the examples you gave are a reflection of implicit bias,
Bias, right.
our underlying attitudes towards people who are different or who have limitations that may not be customary. I know I was working with a case, it's been a couple, actually, I think it was pre-COVID now, and it wasn't a school district per se, but it was an agency that provided before and after school services. And so they interviewed and hired the candidate because she had the prerequisite training and so forth like that, and didn't disclose anything about disability, which is understandable. And then she showed up for work. She showed up at work with a brace on her one leg and then a dog, a service dog. It was like, whoa. And so the thing is that in the job that she was hired for is that, mobility to work with young children in an after-school program was essential. There wasn't any discussion about bringing a service dog into the workplace, and not that that is in and of itself a bad thing. It's just that, in today's world, we have to be conscientious of the impact of a dog and the exposure to other people who may have allergies, fear of dogs, things like that. And so that's something that needs to be explored. And then there were other things because of what was disclosed. Well, then they called me to do an IPM. And so it's like, okay, well, you're qualified from the skills perspective, but now you're presenting a whole host of limitations and accommodations that are needed that, may or may not be readily achievable. And so, she had limited experience. She was young and had limited experience in actually applying for jobs. And was from a different state, so didn't know how California functioned. So
Right.
the employer actually allowed me to sit down and sort of provide guidance to her about her responsibilities as an employee with a disability that was pretty significant. I mean, she could work, she could ambulate, but slowly. She certainly couldn't run after young children. The service dog was a whole nother issue. The brace was another issue. She couldn't kneel down. It went on and on. So,
Right.
yeah.
One of
But
the big caveats that the EEOC said at the very end of this that I didn't add in my notes was that the CEO of the medical clinic should have gone right into an IPM on the first day of work, said we
yeah,
need to schedule an IPM. I'm hearing you about the magnifier and the Zoom tech software. You and I know those are not a big thing. That's
easy peasy.
easy accommodation.
Mhm.
And he didn't meet. He just said, see the door. You should have told me before. Now that you told me now, I'm firing you on the spot. And this is why they're in that kind of hot water, right?
Yeah, yeah. And so simple mistakes cause big problems.
Yep.
Yeah. Yeah. And so as we take a look at our last topic, it's around fitness for duties. And so you open, things have changed. I will just say, I would say things have changed a lot in the last quarter in how some of the occupational medical centers are handling fitness for duties. And so You like me, because I've had different experiences. Usually physical ones have been pretty easy to schedule. Certainly the psychological or behavioral health ones are much more challenging, much more expensive.
Yes.
But my experience over the last couple of months is that the physical ones are getting more difficult too.
Yes.
So why don't you elaborate on that and what the trends are and some of the things we need to be aware of in terms of privacy concerns,
Right.
timelines, costs, employee
Right.
cooperation, et cetera.
So I would say in the past, it could have been true. And when I say in the past, I mean pre-COVID. It could have been true that you could have an employee that you were very concerned about observed behavior, whether it's psychological or physical,
Mhm,
to the point of their ability to perform the essential job functions,
mhm,
to the point where you put them out on paid admin leave pending a fit for duty evaluation. That's the language, however long that may take, right?
mhm,
And in your head, as an HR or administrator, you might think 2 to 3 weeks.
mhm,
Those days have been gone for a long time, but that could have been true
mhm,
pre-COVID, years before that.
mhm,
That's no longer the case. It's harder to find a doctor to do it, number one. Number two, they have a lot of legalities around them. So not all the doctors, the clinics that see our work comp patients know how to do fit for duties or will do a fit for
mhm,
duty. So now it takes longer to identify the doctor. If you need a specialist, that's a whole nother thing. That
mhm,
takes 4 to 6 weeks to get somebody in. But to
mhm,
just have an Occ doctor do it, it still can take 2 to 4 weeks. So in your head, you need to think 8 weeks, 6 to 8 weeks about if you're thinking that you're going to pay them full salary pending this situation,
mhm,
right? And I think you should put more guardrails around, we're going to pay admin leave, right? Like, infinitely, because sometimes it's hard to get the employee to cooperate. I know you'll have more, you have an example that you can use. Yes,
Yes.
several, with signing the medical release, getting the medicals from their doctor to the fit for duty evaluator, and then them cooperating with attending the evaluation,
Mhm,
rescheduling, moving them forward. What started out as a 2 to 4 week now is 6 to 8 weeks, but can even be longer than that. So
mhm,
when you think about the costs of the process, it's not just paying the fit for duty doctor to evaluate the records and see the patient and issue a report that goes to the district and is paid for by the district. And we have a lot of negotiated rates with all of our
mhm,
fit for duty doctors that do this for our member districts. It's that doctors aren't as available because they're busy. It takes longer to get in because they're busy.
mhm,
It's more expensive because they're busy and they
mhm,
can. And to get a report takes a while too. And then now we're having problems, which we didn't have so much problems before because they're working the ed code, right? Is where you get the authority that you can
mhm.
do these fit for duty, independent,
Medical
district
exam.
required medical exam, right?
Mhm,
We're having problems with cooperating
mhm,
employees that won't go, employees that won't sign the medical release, that won't release the records. Sometimes the doctors won't do it without the records. So
mhm,
this can become a process fraught with complication. And when I get the calls, we want to fit for duty. We're going to pay paid admin leave for a few weeks while we get it. That is not this process,
mhm,
not anymore. Maybe it used to be, but that's
mhm.
been years ago.
Yeah, yeah, yeah. It has changed, and particularly and not just employee cooperation, but the you know, again, the ed code doesn't necessarily require that employees sign a consent to participate or consent to exchange medical records that are confidential. However, under HIPAA and other increasing confidentiality issues, the employer, I mean, not the employer, the Fitness for Duty Center is oftentimes now requiring a signed consent. I've seen cases where, employers have been advised by legal counsel that they should do it, and we've been able to do it. And then in other situations where we haven't gotten the consigned consent, because partly on the ADA side of things, the employee has an obligation to cooperate in either providing appropriate medical information or engaging in with the again under the ADA, like the Ed Code, the employer has a right to seek a third-party medical opinion, for clarification, for assessment of, fitness, to work, et cetera. And so I've done some updated research about the whole consent form and things like that. And so it's sort of a little bit of murky waters, because EDCO doesn't say you really need to have it, but then on the ADA say, well, you have the right to do it, but you probably should get a consent. And then you get into the cooperation, and then how much is being released. And I know in my own consent form, I'm very specific that this is only for accommodation purposes. We do not need to see any other medical reports except something that relates to the medical condition for which the employee is seeking accommodation. And so, that can be a little bit more challenging to get then. And my most recent case is that the employee thought that the consent form meant that she got to critique and change the medical questionnaire that I, as a disability management professional, had identified as being critical to resolving accommodation issues in her case. And so then she wouldn't sign because she thought she had the right to, edit and question the questions that the employer and I had already decided.
Because it's an employer requested evaluation, not employee, right?
Yeah,
You're asking the questions of the doctor.
Yeah. So I had to, be careful explaining that, this is just simply you're providing medical records to the evaluation center, or I can help do that. Your employer doesn't see that, but this is part of your responsibility. No, you don't get to edit, et cetera, et cetera. So it got into a big old thing and delays, and we're still dealing with that. But so it's being very clear about what the consent's for, and that they realize, and I do have a sample consent that's more generic for, particularly if there's any direct threat issues, that the employee may be at risk for harm or injury to self or to others, or like students not being, the employee not being able to do something that may interfere with the health and safety of the students. And then, whether or not they are actually able to work, so there's a few criteria in there. And so, but again, as an employer, you have the right to request an independent medical examination, or IME, not a QME, but an IME outside of the workers' comp process, and to clarify those areas of medical concern that exist regarding the employee's medical condition, the nature of the job, and certainly the working conditions.
I was just at a district this morning before this meeting, and they have an interesting case going on, but I've seen a couple interesting creative things happening with respect to this. The one thing that I've seen is before they consider a fit for duty, they're doing an IPM pretty much as a standard thing now, because we need to talk about what is going on in a protected meeting so that we can come to grips with what is the best way to proceed, because they know that the fit for duty process is going to be lengthy and complicated and expensive. It's all those things. And then the second thing that I've seen a lot of districts doing is, I was just talking at a district this morning where instead of doing paid admin leave, what they've been doing is, if the employee is coming forth and saying, I'm having a psychological condition, or in these usually are private health condition situations, and this is why this and this is going on in my classroom. And maybe they're very concerned about health and safety of the children. And so what I'll see them do is they'll, in an IPM process, agree to temporary transitional, put them somewhere else that doesn't place the kids at risk, pending trying to work through these issues, getting the medical information that's needed, getting the evaluation that's needed. That's still tricky, and have to be worked out with the district's advisory council. But sometimes they'll agree to keep them, which keeps them on their salary, right? In their same pay situation. And yet they're not in harm's way, or not placing, because you have such a high responsibility, right, to provide a safe workplace for our students and our other staff. Sometimes they can put them somewhere where it's a very, those responsibilities don't exist. So I thought that was very interesting too. That was a very creative thing that they did, because they also know that the situation they're working on is complicated and is going to take time.
Yeah. Thank you for sharing both of those illustrations. And I think, as you know, I strongly advocate having an IPM before going right into a fitness for duty, because again, it's your opportunity to, one, demonstrate that you're engaging in the interactive process so you avoid any liability for failure to engage. simple, solution. But secondly, it's also an opportunity to explain to the employee what the accommodation process is all about and the rules that apply and et cetera, but also to get necessary information that will help then lay the foundation for the evaluating center. And so that's another piece. And I found that that the employee cooperation tends to be much higher when the IPM is done first, because it's the employer's way of demonstrating their concern, their care, and their compassion, while also protecting their safety. And so it goes a long way in preserving that workplace relationship. I did have a situation where at the employer's request, we went ahead and we got the the fitness for duty scheduled, and then we came back to review the results. Well, there was so much time spent in unraveling why it was leading up to this that it was like, oh, never again. IPM before our fitness for duty for sure. And so what I've also learned is that by doing an IPM, we can actually avert the need for fitness for duty because of discussions and decisions that are made mutually then about next steps. I've had employees, particularly older employees, who may have other conditions developing that may affect their cognitive functioning, for example, and therefore the safety of students. And so they've elected to retire rather than subject themselves to it because they realize they do have a medical condition. And so, and the other thing I will also say about fitness for duty is that the EEOC does advocate that we always first try to go back to the employee's medical provider if and when appropriate.
Yeah, and I think you were involved. This was some years ago now, but it's an interesting case to bring up. We had a teacher who was out on the playground, and I want to say it was kindergarten that she had, but a smaller kindergarten or first grade. And she had them out on the playground and she took all her clothes off. And this is completely out of the norm for this person, right? And they went immediately into an IPM because they were like, what is that?
Yeah,
What's that about? And she was on some medication for a private health condition. And of course, she was mortified too, and got very confused, right? Didn't even, obviously, she got hot. What she explained to them was, I got hot on the playground and I thought I was at home and I took my clothes off. And so then in the IPM, because they were like, they called me, fit for duty. What do we need to do? Psych claim. What is it? What is it? What do we do? And in the IPM, she did go back to her doctor, and you're right, the medication that she was on was such a high dose. She was on a new medication that they were trying for a private health condition, and she got very disoriented and forgot where she was. And they took her off work on sick leave for a while they changed and monitored the medication. But she agreed to all of this and cooperated with all of this because she didn't want this to ever happen again with her little kindergartner first graders. And they got her on a different medication, and she really seemed stabilized. And then the doctor released her back to work without restrictions. So they didn't jump to a fit for duty, right? They went into an immediate IPM, but they had no medical. They said, oh my gosh, what is going on with you? Right. We're concerned about you. How can we best handle this? Because that was a really sensitive situation. And she was super concerned too.
Yeah. It's, I mean, I've got tons of stories I could share as far as, when a fitness for duty is, necessary. And again, the whole level of employee cooperation is really key. And, and how that can hinder the process. And so this is where, again, being mindful, setting some realistic time expectations with the employee as well. Because I've seen a couple situations of where, plans were to go, either I was involved in coordinating or I wasn't. But I remember in one case earlier last year that the employee's medical situation was so unique. It was trying to find the right doctor, the appropriate doctor that could actually evaluate because of the risk potential. And, so we've seen some people go back to work and we've some people leave, and so it's a very interesting dynamic. And I wish we had more time, because I'd love to go into a little bit more about two particular cases, but we don't. And so we'll leave it at that. But just know it's a different process. Well, the process is still the same, but getting there is different than what it used to be. Again, heightened concerns about HIPAA and exchange of medical records, definitely, as you said, the fitness for duty centers are requiring actual medical reports from any treating physician.
Yes.
So that requires the employee's consent. In the past, I always took the medical information I'd acquired during an IPM and summarized it. So it was a nice chronological, historical kind of thing. But now, and I've done that even earlier this year, but now it seems that that's not sufficient. They want to see actual medical reports so that they're going on direct evidence. And I get that. I would be the same way when I'm evaluating cases. I don't want to base my decision, my recommendations on somebody's summary of what they've read. I want direct information, and that's where we've had difficulty getting cooperation and timely release of that kind of stuff. So it's a challenge. So definitely have a consult for all of you listening and hearing about fitness for duties. Definitely have a consult with Felicia or myself or both of us in terms of how best to proceed, what time frame it might take, what alternatives exist. And then definitely, I would strongly encourage you to include starting with an IPM and get the facts, get it laid out.
And advisory council is always really helpful with these super sensitive cases.
Yeah. So, Felicia, any words of wisdom as we start to wrap up the school year? For some, they're already done. For others,
Very excited. School year is close to the end for most of the schools in San Diego County. So, because it's been really busy this year, the last couple of months.
Yes, definitely so. So, and thank you all for being here. Thank you again for participating. I hope you're gaining a lot. We'd love to hear what you get out of these because we are on the alert for topics that we think are interesting, relate to some of the cases we're dealing with. But all with the intent of enhancing your knowledge and education and ability to better manage, employees with medical conditions in the workplace. And so on that note, a reminder, we will be going dark in July. So no podcast on hot topics in the workplace for medical conditions. We will be resuming on Wednesdays. In August. And I think on Wednesdays. We've had to shuffle around because of competing schedules and things like that. So appreciate your flexibility in following our adjustments here and there. But again, we'll see you in August. Have a great summer.
Be well, everyone.
Thank you, Alicia. Thank you, everyone, for being here.